that get picked up by our audio during the presentation. We have two cases on the docket today. The first case is case number 2024-0385, Security First Insurance Company, doing business as Security First Florida, v. Dominic Sincata on behalf of Aurea Sincata, I apologize if I mispronounced that, and Cochrane Insurance. Is the appellant ready to proceed in that case?
Yes, Your Honor.
Appellee?
Yes, Your Honor.
All right, please approach the lectern. For your rebuttal, would you like to reserve some rebuttal time?
Yes, Your Honor. Thank you for reminding me of that. 5 minutes.
5 minutes, okay, give me one moment. All right, are you ready to proceed?
Yes, Your Honor. Good morning, and may it please the court, my name is Mihaela Kabulia, and I represent the appellant in this case, Security First Insurance Company. This case involves the denial of attorney's fees based on a single purported ambiguity in two proposals for settlement that were served by my client, Mr. and Mrs. Sincata. Those proposals were virtually identical, except for the names being different on the proposals. The ambiguity, however, was not identified by the appellees, by the Sincatas, but was identified by the trial judge at the conclusion of the hearing on the motion for attorney's fees.
Counsel, I know that you have raised an issue regarding the idea of notice, opportunity to be heard,
Right.
Due process. But isn't the standard that we look at this de novo?
Yes, Your Honor.
So if it's de novo and you've had months to brief it, research it,
Right.
and present your case to this court, what due process claim do you still have left?
Your Honor, we just wanted to raise that argument for preservation purposes, and also because there were some issues that were not raised right at the hearing, because this was at the conclusion of the hearing, and I want to.
But haven't you had a chance to raise all the
Yes,
issues?
we did, but
Has there been anything up to this point that has prevented you from raising any of the arguments that you would want to raise in regard to the interpretation of this proposal for settlement?
no, Your Honor. No, we raised everything in the brief, and I wanted to point out that this court has a de novo review, obviously, and can review it. The purpose for making the argument was to alert the court that we had limited time, so there are additional arguments in the brief, obviously, and also for preservation purposes. This is not quite a novel argument, but
so then that takes me to my second question, which then points to would be the more substantive argument about the ambiguity,
right.
Whether there's an ambiguity or not, whether the trial court was correct or not. Just for a moment, setting that aside, the legality of whether we have an ambiguity or not, do you think this proposal was poorly drafted? Even if we say there was or was not, if this court rules in your favor or against you, was it poorly drafted?
No, Your Honor, I have to disagree with that statement.
Could it have been drafted better and more clearly than it was?
Your Honor, everything can be drafted better. As the Supreme Court has noticed in Allen versus Nunes, the very nature of language is to be ambiguous. It's hard to make everything super clear. That's why a proposal has to be read in its totality, reviewing every single paragraph to clarify what other paragraphs have meant.
So let's look at the whole proposal. So if we look at the second paragraph, which I think is where the focus is on this case, we have this proposal resolves all damages that would otherwise be awarded to Dominic Sincata. Are we saying his name right, by the way?
Yes, I think so. I'll defer to my colleague.
Sincata?
Sincata,
Okay.
I think.
Dominic Sincata in a final judgment in this action, except for attorney's fees and costs as set forth below. Why was there not something in that paragraph that specified it was Dominic in relation only to the claims that Dominic was presenting against Security First and not to Cochrane Insurance?
So if I may, Your Honor, 2 points on that question. First of all, if you look at page 32 of our brief, we put that paragraph 2 next to Rule 1.442 C2B. It's identical. It mirrors that.
Yeah, it mirrors the
Mirrors that
language.
provision. So it's a strict compliance argument that we have here. That's the first point that I wanted to make. And the second one is, as some of the cases that we've cited in our brief and then supplemental authority, Miami Open, the new case from the third DCA, and the Alamo case from the fourth DCA, point out that a proposal for settlement has to be interpreted in the context in which it is being made. So here, the claim against the insurance agent, Cochran, who was the Cincota's insurance agent, was abated. The whole idea was that there was an agreement between Cochran
But to
and
me, the abating is a little bit of a red herring of an argument because the claim was still out there against Cochran. It's not that it was gone. It's just that you all had agreed not to litigate it at that point in time. But was there anything that would have prevented you from serving a proposal for settlement that would have potentially killed Cochran's claim?
that was not an outstanding claim. It was abated, but it wasn't ripe for
So you're saying,
adjudication.
that abatement means that it couldn't have been settled?
Uh,
That you couldn't have served a proposal for settlement that would have involved Cochran's claims because they were abated at the time?
But there was no connection between Security First and Cochran. That Cochran was their agent. So Security First, by making a proposal for settlement, in the first paragraph, it says this is being made by
I
Security First.
understand.
So the-
But I want to focus in on the abatement. When I saw the abatement argument, it just didn't really swing me that much because I thought you can abate just means pause. You put a pause on litigating those particular claims and it doesn't prevent anybody. We abate claims, we send them back down and then they get settled. You can handle an abated claim. It's just a matter of whether you're litigating it,
But
not about whether you're potentially settling it.
the whole point here was that that claim had not accrued until the claim against Security First was fully resolved. That's what the basis for abatement
But,
was.
I mean,
And if-
could you just tell me very straightforward, just yes or no, could you have served a proposal for settlement that could have resolved the claim against Cochran as well? Could you have put a term in your proposal for settlement that would have resolved it, regardless of the fact that it was being abated?
Your Honor, I doubt we could have made that proposal for settlement because there was no relationship between Cochran. If Cochran were the insurance agent for Security First, then maybe we would have had some basis to do that, but we had no basis to do that. That was their,
Okay.
You didn't represent Cochran,
no.
and was Cochran represented by a separate counsel?
I actually, yes, there would have had to been, but that that count was abated. So
Okay.
the other counsel, in agreement with counsel for Cinquota, agreed that they would abate the case.
All right. And so, counsel, just going back to this paragraph 2, are you saying that because of the way Rule 1.442 is written, that you had no choice but to put this exact language in there, that you couldn't have added on to paragraph 2, Security First, and said that this resolves all damages that would otherwise be awarded to Dominic Cincotta in a final judgment regarding Security First claims?
I'm not saying
Could you
that,
have
Your
added that
Honor.
language?
Yes, we could have added
Okay.
that, Your Honor.
There's a
But-
plethora of cases where they talk about adding language just like that.
Sure.
And they-
I'm not saying that
Okay.
would not have been.
And
a
then
possibility.
we get to paragraph 3, which says, as a condition of this proposal, should this proposal be accepted, Dominic Cincotta agrees that he waives any causes of action for any bad faith claims handling violations or for extra contractual damages. Is that one limited to just Security First?
Your Honor, that was not raised in the briefs, and it was
It
not.
was raised in the briefs.
I mean, it wasn't.
It was raised in the answer
It
brief.
was not the basis. I meant it was not the basis for the trial court
But
finding
from
an
a tipsy
ambiguity.
coachman perspective, we can look at other grounds other than what the trial court considered. If it's in the record, which in this case, the record is, what's really relevant to this record is this proposal for settlement in the language. So it's all there. They made an argument based on paragraph 3 that it doubled up on the ambiguity. And I didn't see a response in your reply brief to that. So what is your response? I do want to give you a chance to respond. They said that this also added to the ambiguity of this.
I beg to differ, Your Honor, because first of all, the paragraph 1 specifically says that that this is made by Security First. Paragraph 6, read in conjunction with paragraph 2 and paragraph 3 make it clear that there's absolutely no doubt that this is made by Security First, and it's going to
Well,
release
Let me,
only
let me
claim.
pause you on that then. So
claim.
paragraph 6, which is the one you say is making it clear, I struggle with thinking that that makes it clear, because paragraph 6 says that Dominic Sincata shall cause to be filed a dismissal of his claim against Security First with prejudice. So that's a dismissal of his claim against Security First.
Right.
Can you have a release without a dismissal? Could you enter into release with a party in a case, and there's no provision in that release that says, and the case will be dismissed? Would that invalidate your release, or can you still have a release that does that?
I would say it's not I mean, what's the benefit of a release that does not dismiss a case? Might resolve, if
So,
it's,
so
if
you're
it's a
saying, you're saying
partial
that,
release.
you're saying that you could have a release that totally releases someone of their claim, but because it doesn't say, and also I will dismiss the claim. If it doesn't have that extra phrase in there, I dismiss the claims too, that the release is invalid? Would that be your position?
I'm saying that it's clearer because otherwise it could be just a partial release, and it might not be clear that the case should be dismissed. So that would create a different type of ambiguity.
Well,
Or different.
Let me tell you my thoughts on it. You could definitely have a release that doesn't say dismissal, and it would still be a completely 100% enforceable release that you would not be able to go after that party for any claim because you released them, even though it didn't have the word dismissal in there. So then takes me to my next question, which is, can you have a dismissal? Can you dismiss a party without a release of claims?
I think that would border malpractice.
Well, people do it all the time. Plaintiffs have claims against a party, and then they dismiss their claim. There's no release that's signed. They just decided to dismiss it without a release in place. So how does this one paragraph in paragraph 6 clear up all ambiguity that's created by paragraphs 2 and 3?
Because it clearly specifies that the Dominic or Aurea Sincata would dismiss their claim against Security First with prejudice. It's not against somebody else. It's not against Cochran here, whose count was abated, was not even an issue, and Security First had moved to dismiss that count. So it doesn't specify. It does. I don't see why Your Honor considers paragraph 6 as not clear.
Oh, it's clear.
very-
It's clear in the concept that it's a dismissal of a claim. And I'm going to stop because I've taken up a lot of your time, but I did have a lot of questions. It's clear it's a dismissal of his claim. That's true. But the question is, do the other paragraphs create confusion as to whether or not, if Dominic Sincata accepts this, that they then lose their claim against Cochran? That's it's not, 6 is clear for what it accomplishes, but I don't know that it undoes ambiguity that may arise from paragraphs 2 and 3. So I'm going to stop there and let my.
I wanted to point out also as to paragraph 3, Your Honor, that there's another reason why there's no ambiguity, because at the time the proposal for settlement was served, there really was no CRN filed by the Sincatas. So there was no bad faith case out there at the time. The proposal should have been accepted or it was served. So that should not have led them to think it's an unreasonable ambiguity.
But what about extra contractual damages? I would agree with you on if you're talking about paragraph 3, the bad faith claims, that would, to me, you're just talking about Security First, or extra contractual damages. To me, that it's unclear what extra contractual damages are they releasing if they accept this, and against who?
There are multiple, and including in the Miami Open case that we submitted as supplemental authority. I want to direct the court's attention to that case because there was a provision that was similarly very broad about releasing. I just want to find that particular case. If you want to give me a moment. That was a very broad provision.
Is that paragraph 8 of that case?
Yes, paragraph 8 that had a really broad language, and the CERT-DCA reviewed that very broad language in connection with other paragraphs of the proposal for settlement and found that read as a whole, the proposal was not ambiguous because it was clear. It was made to resolve only Infinity Auto Insurance Company's claim. So I think there are, and I want to try and find that paragraph if you want to give me a moment, or I'll do that on rebuttal once
It's,
I have
It's
a moment
on,
to
page
exactly to
271
to
of that opinion.
page 270. I can do that on rebuttal once I identify it, but
What's your strongest case? You cited a number of them in your brief.
so the
and a lot
strongest
of them
case
are-
is the Alamo case, the Fort DCA, because it's very similar to the facts of our case. In that case, there was one of the plaintiff had filed a lawsuit against the person who caused the accident and the owner of the vehicle, and the owner of the vehicle served the proposal for settlement, then won on summary judgment and wanted to have its proposal enforced. And what the court did is it found an ambiguity because there were two ambiguity raised by the plaintiff. One was that the release was ambiguous because it might have released the plaintiff.
You're on like 420. I wanted to let you know that. So
Right, I'm saying
Second.
that. It was it could have been interpreted to release not just the owner, but also the tortfeasor. That was rejected by the Fourth DCA because it said looking at at other paragraphs, it becomes clear that it's only the owner that is being released. So the court read the proposal as a whole, not isolated paragraphs. And there was a second argument of ambiguity, which is similar to our argument here. At some point during the proceedings, the plaintiff found out that there was a different entity that rented the car to the tortfeasor, and that entity could have also been interpreted to have been released by the language of the release, because that particular entity was a subsidiary of the owner of the. So the Fourth DCA rejected that argument as well and said it's clear by reading the proposal for settlement in its totality that they meant that it was only releasing the owner of the vehicle. And the court also pointed out that the mention of the owner of the vehicle in one of the provisions meant that it was at the exclusions of others. And to Judge Smith's question regarding why paragraph 2 could not have included Cochrane in it, I think the paragraph 6 offers a really good answer to that. By mentioning security first, Cochrane was excluded from that proposal for settlement. And I think this court should look at that, look at the Alamo case, which is really on point here. One other thing that the Alamo court pointed out was the context in which the proposal for settlement was made there. The plaintiff was unaware that there is that there was another entity that was renting out the car, so it could have not been
Counsel,
interpreted
you're down
as.
into less than 2 minutes into your remaining in your
Right.
time. Just wanted to.
So the court could not have, the plaintiff could not have interpreted that as being an ambiguity. So I think what I would like this court to do is look at the plain language of the entirety of the proposal. And then it becomes very clear that Securities First is the only party that is being released here. The claim against Cochrane was not ripe for, there was no, it had not accrued yet, so it could have not been settled. And case law is clear that if the ambiguity is not reasonable, then the court has to enforce the proposal for settlement. And here the trial judge found simply that all of the other provisions were clear, including the paragraph 3. And I want to address something that Judge Smith said regarding tipsy coachman. I think in this context, Your Honor, tipsy coachman does not apply because they should have had to cross appeal the other findings that were adverse to them, and they did not do that. So they did not cross appeal any of the other findings that the proposal was not ambiguous based on any of the other grounds. So tipsy coachman does not apply in this context to rescue them from not challenging the other findings adverse to them by them. So I think my time is almost up, and I'll reserve part of my.
Thank you.
Thank you. Counsel? Let me know when you're ready.
Thank you, Your Honor. May it please the court, my name is Joseph DeFranco. I'm counsel for Dominic Sincata, and Dominic Sincata on behalf of Aria Sincata. As your honors obviously have heard, this matter arises out of a breach of contract action and an appeal on a motion for fees. And I would first start by giving a little history of the case, and that was there was an application for insurance, and the application that had been bandied about as the application was alleged by my clients not to be the application that they signed. And that led to issues where there was a clear connection between the agent and which is Cochran, and the carrier. And that'll become important in a moment when I speak, but the reality is that there was a lead investigator who met many times with the agent for Cochran. The attorney for Security First at the time met with the agent for Cochran in advance of her deposition for well over an hour and filed a motion for protective order. And that was before, at that point, Cochran was not a defendant in the matter. We added them later. And I, just to be clear, I was the counsel in the underlying case. So with that said, that brings me to one of the issues that I'll be discussing later is that, when we were talking to Novo, we made this argument throughout the case that, that the claims against the agent had to be abated. We filed it. The agent filed a motion to dismiss, or in the alternative, abate. We agreed to do that. But we made a point that our claims against the agent couldn't go forward without some sort of clarification, not clarification, but resolution of the claims against the carrier. And that meant.
Wouldn't this proposal have brought that resolution to let you go forward with the claims against Cochran?
No, Your Honor. There's a case that we cited, Bloomberg, but more importantly, Wells Fargo. It's in my motion in opposition to the motion for fees, where it stated, and I could, if I may, indulge the court for a moment. It specifically stated that we had to. It says. This rule is designed to prevent inconsistent positions by an insured, such as when the insured's claim on one hand that the coverage exists, on the other hand that coverage does not. So, and it goes on to say that in Bloomberg, noting that the holding of Bloomberg was to prevent claims from having to take, or clients from having to take contrary positions in two actions. Federal cases have applied Bloomberg in holding that a claim against an insurance agent for negligence does not accrue until the underlying action against the agent is final. And then it says, and this is important, and more specifically, only after the insured is unsuccessful in recovering damages at the conclusion of the legal proceedings against the insured.
Well, they would have recovered damages.
Exactly, we would have recovered damages.
If they had accepted the proposal. If your clients had accepted the proposal, so you could have gone forward.
Well, if we had that, if we had accepted it, then no, that we would not have been able, in
I
my
don't
view,
understand why.
because our claims weren't ripe at that point. I mean, we're
If
only
you had
ripe
accepted
unless,
the proposal, you would have received money in damages
yes.
from Security First. Based on the case that you just cited, it sounds like at that point you could have gone forward against Cochran, unless I'm
No, it
misunderstanding
says
the case.
we would have to be unsuccessful. That's
Yeah,
what it says.
you would not have been unsuccessful. You would have resolved it through settlement.
Yeah, and it says, and more specifically, only after the insured is unsuccessful in recovering damages at the conclusion of legal proceedings against the insured.
Okay.
So only after we're unsuccessful, but by accepting that
So
proposal,
under your theory, you would have had to take it to trial and win, or win on summary judgment in order to
Win.
be able to sue Cochran?
or lose that trial.
And lose, you don't get
Yeah.
to sue Cochran, but you would have to actually take it to trial or win on summary judgment under your theory.
Under my
in order
theory.
to be able to go against Cochran?
Now, if we had won, then we wouldn't, then our claims wouldn't ripe against. In my view, in my reading of this, is that our claims wouldn't then be ripe against, if we went on a breach of contract against Security First
So
and we
what point would
prevailed.
you be able to sue Cochran? You can't sue them if you lose, and you can't sue them if you win?
If we win, we wouldn't have needed to sue them because our damages would have been paid under the terms of the policy. And in theory, there would be no malpractice against the agent.
But what
And
if
if you
the
lose-
settlement's less than your alleged damages?
Yes, and then so if we'd settled, that's not an unsuccessful proceeding.
Exactly. That's the point. Had you accepted the proposal for settlement, you could have still sued Cochran. You didn't lose your claim.
I believe that they could have said, no, that your claims that you didn't go forward and lose. And that's really, I mean, I think we'd have to lose. If we won, then the need to file a suit against Cochran or pursue them any further would be gone.
But you did lose. So
Yeah, we did lose.
did you pursue Cochran?
Yeah, well, well, I guess as a side note, we did pursue them. We did reach a settlement,
Okay.
but it was nominal and they were bankrupt at the time, or not bankrupt, but they had closed and dissolved. So
Okay.
to be clear on that, I mean, and not anywhere near the amount of damages that, the Syncada suffered.
So on page, I want to get to the ambiguity pretty quickly.
Sure.
The history is pretty interesting. On page 9 of your brief, you state the trial court did not read paragraph 2 in isolation, but read the proposals as a whole, finding them ambiguous. Can you point to me where somewhere in that trial court transcript the judge looked like or made statements that he was reading this as a whole? Because when I read the transcript, he said he was hung up on paragraph 2, and he appeared to be hyper-focused just on paragraph 2. So I guess I want to know where it is that you're saying happened in the transcript
Well,
that showed that he was considering the other paragraphs as a whole.
yes, Your Honor. So, when counsel for the appellee, but on the trial level at the time, he refers to paragraph 6. And the court says, well, Mr. DeFranco did argue that it was vague as to who was being released. And then I spoke up and said, Your Honor, I did. And then I referred to general ambiguity. But in terms of him mentioning paragraph 6, Your Honor, you're correct. Mr. Collum did. But and the court heard argument on that. But the court maintained that he was hung up on that one particular.
Yeah, so that's where I'm trying to figure out where you got that sentence.
I guess my reading is that paragraph 6 was brought up, and he dealt with it, and he basically said that I did bring up ambiguity, and I did argue vagueness, and I don't know if I answered.
I think so. So paragraph 14, you state, neither of the two paragraphs, the first two paragraphs, I think is what you're referring to, distinguish the conditions between Security First and all defendants. So paragraph 1 specifically says, the party making the proposal, Security First Insurance Company. The party to whom the proposal is being made is Dominic Syncada. So what did you mean by that statement in your brief? Because I guess I'm confused as to what you meant by that.
Well, that was going along with our argument, I believe, regarding the fact that there was a connection between Cochran and Security First that made this proposal for settlement more questionable than had these two parties been completely diametrically different.
I didn't see anything in the record that said that there was any response whatsoever to the proposal for settlement where it was asked for clarification. Is that accurate?
No, there was
There was
nothing.
no response at all.
No
So
request.
never asked for clarification.
No, Your Honor.
Okay. Um, This is one of those cases where I think after reading both of the parties' briefs, it doesn't appear like there's much daylight between you two as to the actual standard that the court is going to have to look at for ambiguity. Is there anything I'm missing?
I would
Or
largely
just the
agree with
legal-
that. I would largely agree that the
Okay.
standard is, strict compliance.
So then, we're going forward, I looked at a lot of the cases from our sister circuits, and they're not particularly favorable to your view. That includes Infinity Auto, Bright House, Kiefer, Alamo Financing. Your brief, you only really seem to address Alamo.
Yes.
So I guess the first question I have is, what is your best case that you have cited for us that you believe supports your position that this was ambiguous?
Well, Your Honor, I'd probably point, not necessarily, we're sitting as the appellee. Our argument here is facts,
Okay.
and facts do matter. And in every one of these cases, there's a distinguishable fact.
Okay, that's great. So let's talk about that.
Sure.
Tell me what the distinguishing fact in Infinity Auto.
Infinity Auto?
Because the only one you have in your brief
Yes,
that you distinguished is Alamo.
is multiple, if I'm not mistaken, actually a release. In that case, there was a release. No release here in this case. I just want to make,
But the rule and the statute don't require a release, right?
no,
You're
they
saying
don't,
that
but
it would help
again,
to clarify?
but that was something that was provided in Infinity, and it made, where the court could glom onto that and say, yeah, here, the release makes it clear. And that's particularly the case in Alamo versus Mazoff as well. But with respect to Infinity, that's, the issue is that virtually every one of these cases is one where a release was involved in this, whereas in
that's
our
the
facts,
key
no
distinguishing.
release. So, on that note, counsel for the appellant brought up Alamo and discussed it at length toward the end of her presentation. And it is important to note that there were two defendants. The release as to the driver, and this was a rental car situation where plaintiff had sued the driver and the renter of the vehicle, Alamo. But the issues in dispute had nothing to do with the driver. It was where the plaintiff at the end was hanging on to this issue that they were in fear of releasing Alamo Rental. And they said, hey, the release called for releases of subsidiaries and, companies that were within that umbrella. When they argued this, Alamo Finance, again, the defendant, argued that Alamo Rental was not a subsidiary, that it was an affiliate. And they made that distinction. The court stuck to that and said, no, if they weren't a subsidiary, you would not have been releasing.
And you never alleged that Cochran was a subsidiary
No,
of
no.
Security First.
No, they weren't. We did feel like there was a connection where Security First had a vested interest in trying to,
Sell the product.
yeah, in that we felt, and I think there was a clear issue where they believed that their actions, and I mean Cochran's, could have inured to Security First somehow, because it all involved this application and who had possession of it. And the agent had it, and Security First tried to get it. There was an issue about the process, but again, that was in the underlying. I don't want to obviously
Did
go
the
into
trial
it.
court ever make any factual findings?
I'm sorry, Your Honor?
Did the trial court ever make any factual findings that established any sort of
No, Your Honor.
relationship?
No, it was just part of my argument in terms of the motion in opposition to the motion for fees. So, and I would argue literally, again, in every case, the facts distinguish this. In Alamo, in Bright House.
Maybe as far as the wording of some of these releases, but it seems based on those cases, what the overriding principle is that a paragraph or something written in isolation in one of these proposals, that is a very general release, which is kind of what you have in paragraph 2, cannot make what is otherwise unambiguous the remaining portions of the proposal, which seems to be what you have in at least paragraphs 1 and paragraph 6. But you're saying that the main thing that distinguishes them is because there was no actual drafted release here
Correct.
for you to look at?
Yes. And in
Okay.
addition, in some instances, too, we are only dealing with one defendant in these cases.
No, not in the other case.
Not in Alamo.
Not in any of them. That was the whole
No,
point.
I mean, for instance, Infinity, I believe there was only one
No,
defendant.
the Infinity was not one defendant. It was also about a different medical company.
Exactly,
that they
but those
could have
were,
released.
those were prospective. They weren't in that particular case. So they weren't, the fear was that Infinity was trying to get releases for future cases, not necessarily involved in that particular case, if I'm not mistaken. I mean, I could be
I
wrong, Your
think-
Honor.
I think you're right and wrong at the same time. I think you're right in that it wasn't against another medical company called Prime, but there was a separate claim against Prime going on at the same time
Okay,
based
yeah,
on a whole separate thing of facts.
Yes.
But it was the same facts, but it was a separate medical company for
Yeah.
sure.
and
There's no argument here that this was a joint proposal. There was no language in this.
no, they actually drafted two separate release proposals.
No, I mean more of a joint proposal between Security First and Cochrane. There's nothing.
Nothing.
Okay.
And
And would you agree that there was nothing that would have made it your understanding, your client's understanding, that this was a joint proposal?
other than them coming out and saying that this was, that we were doing this on behalf of Cochrane too. Again, this is one where, the standard is strict compliance.
Wouldn't they have needed to say that it was a joint proposal in order for your side to have a reasonable belief that it was?
I think it could be, it could be inferred. I don't think it has to have an explicit statement for us to have that, to make that argument.
Doesn't Rule 1.442C3 specifically say that a joint proposal shall state the amount and terms attributable to each party?
Yeah, it exactly does, Your Honor. And I think.
So
that-
how, if Cochrane is never mentioned in this proposal for settlement, how is this a joint proposal under the rule that requires the proposal to state the amount and terms attributable to each party?
Because it argues, it says all claims that could otherwise be brought. That's, I'm not talking in that, that's the proposal for settlement had that language. And it did, paragraph 2 said all claims that could be brought, not just necessarily brought against Security First, but it did say that. In paragraph 2 of the proposal, and both proposed, there were two actual separate proposals for settlement. And each of them had, identical language, and obviously they both said that.
You have Kiefer was a pretty interesting case. Do you have any argument as to why Kiefer is different, other than the fact that there was a release in Kiefer?
Yeah, it was just that, there was a release.
Okay.
And
And there's nothing in either the rule or the rule or the statute that requires a release for a proposal for settlement.
no, but the problem, the issue would be that it would have been more clear. We might not be here today had Security First had a release, because then they could say, no, here's the release. We never mentioned Cochrane one time in this release. I do, with the time I have remaining, I would like to mention or go to the issue of surprise and lack of due process. First of all, my motion in opposition to their motion for fees, was replete with references to ambiguity. And ambiguity and vagueness are one and the same. If you look up thesaurus.com, the first synonym for vagueness is ambiguity. I mentioned it at the hearing, and the court even, recognized that I had brought it up. And there was no.
Your motion was pretty specific. It said proposals do not specify if defendant Security First intends to resolve all damages as to itself and defendant Cochrane, or just those claims against defendant Security First individually.
Yeah. And so the fact that they are claiming they were surprised, it doesn't, it's not consistent with reality. And I would point to the transcript of the hearing. The judge makes this argument, hey, I'm hung up on paragraph 2. The very next thing out of counsel for the defendant at that time was paragraph 6. Look at paragraph 6. He understood, he knew full well what was coming. And now 2 years later, with the benefit of, recollection and with the benefit of being able to review this, their arguments are still the same. It's paragraph 6 cures paragraph 2.
What about paragraph 1?
Well, today their arguments are, they're not different in any way really than what the argument that he made that day. So he wasn't caught by surprise. And even if he could, those things were mentioned. Those clearly were mentioned. They were mentioned at the hearing. They were mentioned in my motion. That the proposals for settlement were generally vague. And I specifically referred to that one section. Didn't call it paragraph 2, but I made reference to it. And with that, my time's up.
Thank you, counsel.
I want to address a few of the.
Counsel, I'm sorry.
Oh,
You were, part of your eating into your rebuttal time was responding to a counsel, so you're going to have a total of 1 minute, 7 seconds for your rebuttal. Okay.
Thank you very much, Your Honor. Oh, it still looks like a minute. Okay. I wanted to point out a few things. It appears that my colleague is making an argument that's based on equity, that they could not have potentially accepted the proposal for settlement because if they had done that, their claim against Cochran would not have ripened and they could not have pursued Cochran. And I think that's improper precisely because the statute and the rule require strict compliance, and that should not be the case that a party making a proposal for settlement is penalized for under such circumstances and cannot rely on that proposal when it prevails. And then one of the arguments that my colleague made is that paragraph 2 contains language that it would extinguish all claims that could have been brought. I don't see that language in the paragraph. I think that's incorrect. The paragraph just says it would resolve all damages that would otherwise be awarded to Dominic and in a final judgment in this action. And then as to the argument.
Counsel, your time has expired if you just want to wrap it up.
Right. I would ask the court to reverse and remand because the proposal, when read as a whole, is clear and ambiguous and should have been enforced.
All right. Thank you very much.
Thank you.
All right. Thank you to both counsel for your preparation and for the presentations here today. Take it under advisement and we'll be in brief recess.
Thank you.